The Employees' Compensation Act 1923, as amended through Amendment Act 2017. 16. Returns as to compensation. The state government may, by notification in the Official Gazette, direct that every person employing employees, or that any specified class of such persons, shall send at such time and in such form and to such authority, as may be specified in the notification, a correct return specifying the number of injuries in respect of which compensation has been paid by the employer during the previous year and the amount of such compensation together with such other particulars as to the compensation as the state government may direct. 17. Contracting out. Any contract or agreement whether made before or after the commencement of this act whereby an employee relinquishes any right of compensation from the employer for personal injury arising out of or in the course of the employment shall be null and void insofar as it purports to remove or reduce the liability of any person to pay compensation under this act. 17a. Every employer shall immediately at the time of employment of an employee inform the employee of his rights to compensation under this act in writing as well as through electronic means in English or Hindi or in the official language of the area of employment as may be understood by the employee. 18. Proof of age, repealed. Rep. by the Workmen's Compensation Amendment Act 1959, 8 of 1959, Section 11, W.E.F. 1959. 18a. Penalties. 1. Whoever a. fails to maintain a notice book which he is required to maintain under subsection 3 of Section 10 or b. fails to send to the Commissioner a statement which he is required to send under subsection 1 of Section 10a, or c. fails to send a report which he is required to send under Section 10b, or d. fails to make a return which he is required to make under Section 16, or e. fails to inform the employee of his rights to compensation as required under Section 17a, shall be punishable with fine which shall not be less than 50,000 rupees but which may extend to 1 lakh rupees. 2. No prosecution under this section shall be instituted except by or with the previous sanction of a commissioner, and no court shall take cognizance of any offense under this section, unless complaint thereof is made within 6 months of the date on which the alleged commission of the offense came to the knowledge of the commissioner. 19. Reference to commissioners. 1. If any question arises in any proceedings under this act as to the liability of any person to pay compensation, including any question as to whether a person injured is or is not an employee, or as to the amount or duration of compensation, including any question as to the nature or extent of disablement, the question shall, in default of agreement, be settled by a commissioner. 2. No civil court shall have jurisdiction to settle, decide or deal with any question which is by or under this act required to be settled, decided or dealt with by a commissioner or to enforce any liability incurred under this act. 20. Appointment of commissioners. 1. The state government may, by notification in the Official Gazette, appoint any person who is or has been a member of a state judicial service for a period of not less than 5 years or is or has been for not less than 5 years an advocate or a pleader or is or has been a gazetted officer for not less than 5 years having educational qualifications and experience in personnel management, human resource development and industrial relations to be a commissioner for employees' compensation for such area as may be specified in the notification. 2. Where more than one commissioner has been appointed for any area, the state government may, by general or special order, regulate the distribution of business between them. 3. Any commissioner may, for the purpose of deciding any matter referred to him for decision under this act, choose one or more persons possessing special knowledge of any matter relevant to the matter under inquiry to assist him in holding the inquiry. 4. Every commissioner shall be deemed to be a public servant within the meaning of the Indian Penal Code 45 of 1860.